The marble halls of the Supreme Court fell silent. Justice Amy Coney Barrett's gavel struck with finality as she fixed her steely gaze on the young woman standing before the bench. A showdown was unfolding unlike anything the court had witnessed in modern history. White House Press Secretary Caroline Levit stood motionless, facing the 9 most powerful legal minds in America. At just 28, she was the youngest person ever to face potential contempt charges from the nation's highest court. The crime? Daring to criticize their ruling. "Miss Levit," Barrett intoned, her voice cutting through the chamber like a scalpel, "this court finds your repeated statements about our recent decision deeply concerning. You stand perilously close to contempt." The gallery held its collective breath. Reporters' fingers hovered over keyboards, ready to document what everyone assumed would be a humiliating capitulation. Barrett continued, her tone carrying the weight of inevitable consequence. "You have 7 days to retract your statements and issue a formal apology, or this court will have no choice but to refer this matter for criminal prosecution." But instead of cowering, instead of offering the expected apology, Levit calmly opened a leather portfolio. When she spoke, her voice carried no tremor, no hesitation. "Justice Barrett, I've prepared a 15-page legal analysis explaining why my statements are not only protected but legally correct." The chamber froze in disbelief. No one had expected this twist, least of all the justices themselves. What happened next would send shockwaves through Washington's corridors of power and rewrite the boundaries between the branches of government. Have you ever witnessed someone standing their ground against overwhelming authority? Hit that subscribe button now and join us as we dissect this extraordinary constitutional confrontation. Justice Amy Coney Barrett had risen to prominence as the court's intellectual fortress. Appointed in 2020 at age 48, the former Notre Dame law professor had established herself as a formidable judicial presence. Her precise legal reasoning and unflinching demeanor commanded respect from allies and opponents alike. At 52, Barrett had become one of the most influential voices on the conservative-leaning court, a constitutional scholar particularly sensitive to criticism she deemed uninformed or misleading. Across the marble divide stood Caroline Levit, representing a new generation in Washington politics. Appointed White House press secretary just 6 months earlier, she had quickly gained recognition for her direct communication style and unflinching defense of administration policies. What few knew, what her own White House colleagues hadn't fully grasped, was Levit's academic background. Behind the press podium stood a mind that had graduated with honors from St. Anselm College, with a double major in politics and communications, followed by law studies she'd quietly completed while working previous government roles. The conflict had ignited 3 weeks earlier, when the Supreme Court issued a controversial 5-4 ruling in Fairfield v. Department of Education, limiting federal oversight of state education policies. During a subsequent White House briefing, Levit had unleashed criticism sharper than typical diplomatic language. This ruling, she had stated with clinical precision, represents a fundamental misreading of precedent and legislative intent. The majority opinion ignores 70 years of established jurisprudence and substitutes judicial preference for constitutional principle. The comments sent conservative media into a frenzy. Legal analysts debated whether Levit had crossed the invisible line from criticism to contempt. The stakes were enormous. If found in contempt, she faced not just potential imprisonment, but the destruction of her rising career. For Barrett and the court, the confrontation represented a test of judicial authority in an era of diminishing institutional respect. The unprecedented summons for Levit to appear before the full court created a national sensation. Constitutional scholars struggled to find historical parallels. The New York Times called it a constitutional crisis without modern precedent, while the Wall Street Journal described it as a collision between judicial authority and executive communication rights. As Levit stood in the chamber that fateful morning, her legal team had advised immediate capitulation. The White House counsel had prepared a statement of contrition. The president himself had suggested a conciliatory approach. But unbeknownst to them all, Levit had spent 3 sleepless nights researching Supreme Court precedents on contempt, free speech limitations, and the historical relationship between government branches. So when Barrett delivered her 7-day ultimatum, the room waited for Levit to back down, to offer the expected apology. No one anticipated what came next. Justice Barrett's expression revealed momentary surprise as Levit opened her portfolio. Several justices exchanged glances. Chief Justice Roberts leaned forward slightly, his interest visibly piqued. "Ms. Levit," Barrett said, her voice carrying a warning note. "This proceeding is not a debate. The court has made its position clear regarding your statements." Levit nodded respectfully. "I understand, Justice Barrett. However, before the court proceeds with its contemplated action, I believe it's my responsibility to address the legal basis for any potential contempt finding." Barrett's eyes narrowed. "Proceed, but be aware that your response here may factor into the court's ultimate decision." The warning was clear, but Levit remained composed as she referenced her prepared materials. "Thank you, Your Honor. I'd like to begin by addressing the specific legal standard for contempt of court as established in Bridges v. California. The reference to a 1941 Supreme Court decision caused Justice Sotomayor to look up with visible interest. "In Bridges," Levit continued, her voice steady, "this court held that criticism of judicial decisions, even harsh criticism, is protected by the First Amendment unless it presents a clear and present danger to the administration of justice. My statements, while direct, presented no such danger. If you're as shocked as the justices were at this young press secretary's legal knowledge, tap that like button now. We're just getting started." Justice Alito interjected, his tone betraying irritation. "Ms. Levit, you stated that this court ignored 70 years of precedent. That goes beyond criticism to questioning the court's integrity." Levit turned to address Alito directly. "Justice Alito, in New York Times v. Sullivan, this court established that debate on public issues should be, quote, uninhibited, robust, and wide open, and may include, quote, vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. The court specifically included judges within this framework." The chamber remained silent, as Levit continued methodically addressing each element of potential contempt. Furthermore, in Craig v. Harney, this court held that judges are supposed to be men of fortitude, able to thrive in a hardy climate. The opinion explicitly protected criticism of judicial decisions, noting that what transpires in the courtroom is public property. Justice Barrett's expression remained stern but attentive. "Ms. Levit, those cases primarily address the rights of private citizens and the press. As a government official speaking in an official capacity, your situation may be distinguishable." It was the opening Levit had anticipated. She turned to page 8 of her analysis. "Justice Barrett, I respectfully direct the court's attention to Garrison v. Louisiana, where this court specifically addressed critical speech by government officials. In that case, a district attorney's critical comments about judges were held to be protected speech. The court stated that speech concerning public affairs is, quote, more than self-expression, it is the essence of self-government." The tension in the chamber intensified as observers realized this was not simply defiance, but a substantive legal argument. Reporters stopped typing, transfixed by the unexpected direction of the proceedings. Justice Kagan leaned toward her microphone. "Ms. Levit, while your knowledge of precedent is noted, there's a difference between criticizing a decision and suggesting the court deliberately misinterpreted the law. The latter implies bad faith." Levit nodded respectfully. "Justice Kagan, I appreciate that distinction. However, in Wood v. Georgia, this court protected a share of statements that directly accused judges of bias and political motivation, statements far more pointed than my own. The court held that the role that elected officials play in our society makes it all the more imperative that they be allowed freely to express themselves on matters of current public importance." Barrett's expression had subtly shifted from stern disapproval to reluctant engagement with Levit's legal reasoning. "Ms. Levit, you've cited several cases, but none of them specifically addresses statements made by White House officials about Supreme Court decisions." "That's correct, Justice Barrett," Levit acknowledged. "But I would argue that absence of specific precedent restricting such speech should favor protection rather than limitation. As this court noted in Texas v. Johnson, we have a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open." The dynamic in the chamber had transformed. What began as a reprimand had evolved into a substantive legal discussion. Levit continued citing relevant cases, explaining their application to her situation with remarkable precision. Justice Thomas, who rarely spoke during proceedings, broke his silence. "Ms. Levit, while your legal analysis is thorough, there remains the question of respect for institutions. Your statements could undermine public confidence in the judiciary." Levit turned to address Thomas directly. "Justice Thomas, I deeply respect your concern. However, in Landmark Communications v. Virginia, this court specifically addressed that issue, stating that, quote, injury to official reputation is an insufficient reason for repressing speech that would otherwise be free." The opinion further noted that, quote, "The law gives no protection to the judge who would hide behind the cloak of office to escape public criticism." The quote hung in the air, its directness causing several justices to shift in their seats. The confrontation had escalated beyond anyone's expectations. Rather than a penitent press secretary accepting the court's authority, Levit had transformed the proceeding into a sophisticated constitutional debate, and she showed no signs of backing down. Think this young press secretary is right to challenge the Supreme Court this way? Or has she gone too far? Comment below with your thoughts on where the line should be drawn. Justice Barrett, visibly reassessing her approach, leaned forward. "Ms. Levit, are you suggesting that there are no limits to how administration officials can characterize court decisions?" "Not at all, Justice Barrett," Levit replied. "I recognize that limits exist. Direct incitement to disregard court orders would clearly cross the line established in Bridges, but criticism of legal reasoning, even strong criticism, falls squarely within protected speech under this court's own precedents." As Levit continued her methodical legal analysis, the atmosphere in the chamber transformed completely. What began as a disciplinary proceeding had become an unexpected showcase of constitutional interpretation, with the youngest person in the room demonstrating a command of precedent that had clearly caught the justices by surprise. Levit's voice, which had maintained steady confidence throughout, took on an even more assured tone. "If I may, I'd like to address the historical context that further supports the constitutional protection of my statements." Justice Barrett, who had planned to issue a simple ultimatum rather than engage in constitutional debate, found herself nodding permission. The dynamic had shifted dramatically, with several justices now leaning forward with evident interest. "Throughout our nation's history," Levit continued, "tensions between the executive branch and this court have resulted in far more pointed criticisms than mine, without contempt proceedings. President Jefferson called Marshall's opinion in Marbury v. Madison, quote, twistifications. President Jackson reportedly said of Marshall, 'John Marshall has made his decision, now let him enforce it.' President Lincoln directly challenged the legitimacy of Dred Scott v. Sanford in his inaugural address." Levit paused, allowing the historical context to register with the justices and observers. She then moved to more recent examples. In 2010, President Obama criticized the court's decision in Citizens United during his State of the Union address, with 6 justices present. In 2017, President Trump described a judge who ruled against his administration as a, quote, so-called judge. Neither faced contempt proceedings. Justice Sotomayor interjected, "Those were statements by presidents, Ms. Levit. Your position is different." "Respectfully, Justice Sotomayor," Levit responded without hesitation. "The legal standard for contempt doesn't create a separate category for presidential speech versus other executive officials. And historically, press secretaries have frequently criticized court decisions. Ron Ziegler under Nixon, James Brady under Reagan, D.D. Myers under Clinton, and Kayleigh McEnany under Trump all issued statements critical of specific Supreme Court rulings." Levit then moved to what would become the most powerful portion of her presentation, a direct analysis of her actual statements compared to the legal standard for contempt. "If I may draw the court's attention to the precise language I used," she said, producing a transcript of her press briefing. "I stated that the ruling, quote, represents a fundamental misreading of precedent and legislative intent. This is a legal assessment, not a personal attack. I said the majority opinion ignores 70 years of established jurisprudence. This is a claim about legal methodology, not judicial integrity." She looked directly at Justice Barrett. "Under Bridges, contempt requires a, quote, clear and present danger to the administration of justice. My statements present no such danger. They question legal reasoning, not judicial legitimacy." Barrett, who had entered the chamber confident in her position, now found herself in an unexpected situation. The press secretary she had summoned for reprimand was presenting a sophisticated constitutional defense that directly cited the court's own precedents. "Ms. Levit," Barrett said, "while your knowledge of precedent is impressive, there remains the issue of your position as White House press secretary. Your words carry the implied authority of the executive branch." It was precisely the opening Levit had anticipated. She turned to the final section of her analysis. "Justice Barrett, that's an important distinction that I'd like to address directly. In Garcetti v. Ceballos, this court held that when public employees speak pursuant to their official duties, their speech may receive less First Amendment protection. However, that case specifically distinguished between internal workplace speech and public commentary on matters of public concern. Levit's command of case law was remarkable, particularly as she cited specific page numbers and direct quotes from opinions. Several clerks could be seen frantically checking her references, only to confirm their accuracy. More importantly, she continued, in Lane v. Franks, this court clarified that speech by public employees on matters of public concern deserves robust protection. A Supreme Court decision affecting national education policy is unquestionably a matter of public concern. My role as press secretary inherently involves communicating the administration's positions on such matters. The gallery remained spellbound as Levit methodically constructed her defense. What had begun as an attempt to discipline a presumed novice had transformed into a masterclass in First Amendment jurisprudence. Justice Barrett, recognizing the unexpected turn the proceeding had taken, attempted to redirect. Ms. Levit, this court has the authority to defend its institutional integrity. Your statements, regardless of their technical legal status, showed disrespect for this institution. Levit nodded respectfully before delivering her most powerful point. Justice Barrett, I have the deepest respect for this court as an institution. It is precisely because of that respect that I believe we must engage in robust debate about its decisions. She paused, then quoted directly from Barrett's own judicial writings. As you yourself wrote in your 2019 article in the Notre Dame Law Review, respectful disagreement is not disrespect. Indeed, the ability to criticize judicial reasoning is essential to the health of our constitutional democracy. The chamber fell completely silent. Barrett's own words, quoted verbatim and in context, had effectively undermined the basis for the contempt proceeding. Several justices glanced at Barrett, waiting for her response. Did you expect this brilliant tactical move? If you're impressed by how this young woman outmaneuvered the Supreme Court with their own words, share this video now with someone who appreciates intellectual courage. After a moment that seemed to stretch eternally, Justice Barrett spoke. Ms. Levit, I appreciate the thoroughness of your presentation. The court will need to consider the points you've raised. She glanced at Chief Justice Roberts, who nodded almost imperceptibly before addressing Levit. This court will take your arguments under advisement. We'll issue our determination within 48 hours. This proceeding is adjourned. As the justices rose to exit, the gallery erupted in whispered conversations. Legal observers who had come expecting to witness a simple disciplinary proceeding had instead seen something extraordinary. A young press secretary had just delivered a constitutional law lecture to the Supreme Court, using its own precedents to defend her right to criticize it. The triumph was evident not in shouting or celebration, but in the simple fact that Levit had transformed what was meant to be her reprimand into a serious constitutional deliberation. As she gathered her materials, preparing to face the media storm outside, both friends and critics recognized they had witnessed something remarkable. The emergence of a legal mind that had just stood toe-to-toe with the nation's highest court. The moment Caroline Levit exited the Supreme Court building, she was engulfed by a sea of reporters. Camera flashes illuminated her path, as journalists shouted questions from every direction. Rather than offering impromptu comments, she simply stated, "I've presented my position to the court. Out of respect for their deliberative process, I'll reserve further comment until they've issued their determination." This measured response, contrasting sharply with the media circus surrounding her, only amplified the impact of what had transpired inside. Within minutes, legal experts across the country began dissecting the extraordinary confrontation. At Georgetown Law Center, Professor Lawrence Tribe was hosting an impromptu discussion with stunned constitutional law students. What we witnessed today was unprecedented, he told them. A press secretary transformed a contempt proceeding into a substantive First Amendment seminar, using the court's own precedents with remarkable precision. CNN's legal analyst Jeffrey Toobin appeared visibly energized on air. "I've covered the Supreme Court for decades, and I've never seen anything like this." Levit didn't just defend herself, she essentially delivered a guest lecture on First Amendment jurisprudence to the justices themselves. Conservative legal commentators were similarly impressed, though more measured. Former federal judge Michael Luttig noted, "While I may disagree with Levit's characterization of the court's decision, her legal defense today was extraordinarily well crafted. She's raised legitimate constitutional questions that the court will need to address thoughtfully." As legal analyses flooded cable news and social media, another narrative emerged, the biographical revelation about Levit that had escaped public notice until now. Her law studies, completed quietly while working in government, had never been highlighted in her White House biography or public profiles. The Washington Post published a profile within hours. Behind the press secretary podium, Caroline Levit's unknown legal background. The piece detailed how Levit had completed her law studies through an evening program while working on Capitol Hill, maintaining a remarkable 3.9 GPA while juggling a demanding political career. A former professor, speaking anonymously, described her as one of the most gifted constitutional law students I've encountered, someone who could recite case law from memory and apply it with unusual creativity. Inside the White House, the mood shifted from tense concern to cautious optimism. Officials who had advised Levit to simply apologize now gathered in the Chief of Staff's office, watching legal experts praise her performance across networks. "She never told us she was going to do this," one senior advisor was overheard saying. "We had the apology statement ready to go. Nobody knew she'd spent the weekend building a constitutional defense." The president, who had initially worried about the political fallout of a contempt citation, called Levit personally. According to sources familiar with the conversation, he simply said, "You made history today. Whatever happens next, I'm proud to have you representing this administration." As we wait for the court's decision, comment below with your thoughts. Should government officials be allowed to harshly criticize the Supreme Court? Or should there be limits to preserve judicial authority? Meanwhile, inside the Supreme Court chambers, an extraordinary conference was taking place. The 9 justices, who rarely convened emergency discussions, gathered to address the unexpected constitutional challenge Levit had presented. According to sources close to the court who later spoke to The New Yorker, Justice Barrett opened the discussion by acknowledging the complexity of the situation. "We summoned Ms. Levit expecting a straightforward contempt proceeding. Instead, she's presented us with a sophisticated First Amendment defense that directly cites our own precedents. We need to consider our response carefully." Several justices reportedly expressed admiration for Levit's legal acumen, regardless of their views on her original comments. Justice Kagan supposedly remarked, "Whatever we decide, I think we've all gained a healthy respect for her constitutional understanding." As the justices deliberated, law schools across the country scrambled to incorporate the hearing into their curriculum. Harvard Law announced a special symposium, Executive Speech and Judicial Criticism, Constitutional Boundaries After Levit. Stanford Law scheduled a panel discussion featuring former Supreme Court clerks analyzing the constitutional questions raised. Legal scholars began publishing emergency analyses in online law reviews. Yale Law Journal's forum featured a piece titled, "Contempt, Power and Criticism: The Court's Dilemma After Levit's Defense." The article outlined the difficult position the court now faced, either retreating from its contempt threat and appearing to concede Levit's constitutional arguments, or pursuing contempt, despite the formidable First Amendment defense she had constructed. Social media exploded with reactions from ordinary Americans. The hashtags #GalGenius trended nationally, along with #Supreme Showdown. Young women across the political spectrum expressed particular admiration for Levit's poise under pressure, with TikTok videos analyzing her presentation style garnering millions of views. 48 hours later, as promised, the Supreme Court issued its decision. In an unusual 9-0 determination, the court announced it would not pursue contempt proceedings against Levit. The brief statement acknowledged the important First Amendment considerations raised during the hearing and reaffirmed the constitutional protection of robust debate regarding judicial decisions. Justice Barrett issued a concurring statement that legal scholars would analyze for years to come. While this court maintains its authority to protect the integrity of judicial proceedings, we must also respect the constitutional boundaries on that authority. Ms. Levit's presentation reminded us that our own precedents have consistently protected critical commentary on judicial decisions, even when that criticism is harsh or pointed. A democracy that cannot tolerate criticism of its courts is no democracy at all. The decision represented not just a personal vindication for Levit, but a significant constitutional affirmation of the right to criticize judicial decisions. Legal historians would later mark it as a defining moment in the relationship between the executive and judicial branches. At her first press briefing following the court's decision, Levit maintained her characteristic composure. When asked about her remarkable legal defense, she simply stated, "I believe deeply in both the First Amendment and the importance of the Supreme Court as an institution. I'm grateful the justices engaged so thoughtfully with the constitutional questions at hand. The long-term implications extended far beyond the immediate controversy." Law schools reported a surge in applications, particularly from women and young professionals inspired by Levit's example. Constitutional law professors noted increasing student interest in First Amendment jurisprudence and separation of powers. Perhaps most significantly, the relationship between press secretaries and the court evolved. Future administrations became more careful and precise in their criticisms of court decisions, focusing on legal reasoning rather than questioning judicial motives. Simultaneously, the court became more restrained in its responses to executive criticism, recognizing the constitutional boundaries Levit had so effectively highlighted. 6 months later, Justice Barrett invited Levit to speak at Notre Dame Law School about executive judicial relations. The event, which sold out within minutes, symbolized the remarkable transformation from adversaries in a contempt proceeding to mutual participants in constitutional dialogue. In her introduction, Barrett acknowledged the extraordinary circumstances of their first substantive interaction. Ms. Levit reminded us all that robust debate about judicial decisions strengthens, rather than weakens, our constitutional system. Her legal acumen surprised many, but it shouldn't have. In America, legal brilliance can emerge from unexpected places, and constitutional understanding isn't limited to judges and professors. As Levit took the podium to thunderous applause, the journey from potential contempt to defendant to respected constitutional voice was complete. What had begun as an attempt to silence criticism had instead amplified it and established new precedent for protected political speech. The press secretary had indeed proven herself a legal genius, not through academic credentials or judicial appointment, but through the powerful application of constitutional principles when it mattered most. If this analysis of a historic constitutional confrontation has enlightened you, please take a moment to like and subscribe to our channel for more in-depth political and legal analysis. Comment below with your thoughts on the balance between judicial authority and free speech, and don't forget to hit the notification bell so you never miss our latest videos. Thank you for joining us on Caroline Now.